On the 3rd of January 2022, a jury in San Jose came back with its verdicts. 4 of them were guilty. 0 of them were about a patient. Elizabeth Holmes was convicted of defrauding investors. On every count relating to the people who actually gave blood, the jury acquitted her. She is serving more than 11 years. Not one day of it is for the blood. That gap is not an accident, and it is not a loophole. It is the machinery of this case working exactly as designed, and the same machinery is running somewhere in your life right now. 3 things to hold. Why 0? Who was paid to catch this and did not? And where you're standing in a chain like this one. Theranos sold a sentence. A few drops of blood from a finger and a full panel of results. It was a good sentence. At its peak, the company was valued at roughly $9 billion and employed around 800 people. The device was called the Edison. The public test menu listed more than 200 blood tests. In practice, the Edison was only ever used for a small fraction of that menu, roughly a dozen. The rest ran on conventional analyzers bought from other manufacturers, the same machines any hospital lab uses, with the finger stick samples diluted to make them big enough to work. This is the part that matters, and it is the part usually skipped. Theranos was not a technology company that failed to ship. It was a working clinical laboratory in Newark, California, processing real samples from real people. Court records and regulator filings put that lab at roughly 890,000 tests a year. Those results went to Walgreens. From Walgreens, they went to physicians. From physicians, they went to patients who had no idea any of this was in question. In 2014, an employee named Tyler Shultz raised concerns internally about the company's proficiency testing. He was the grandson of a board member. He put it in writing. The filing that followed was not his. Inspectors from the Centers for Medicare and Medicaid Services concluded their survey of that lab on the 23rd of December, 2015. The notice went out on the 25th of January. It used a specific regulatory phrase, one with a legal definition, not a rhetorical one. Immediate jeopardy to patient health and safety. Theranos went on to void or correct results. Tens of thousands of amended reports went back out to the physicians who had ordered them. Some of those physicians had patients who later took the witness stand. Erin Tompkins testified that a Theranos blood test indicated she was HIV positive. A later test showed she was not. Brittany Gould testified about Theranos results that incorrectly suggested she was miscarrying. Both of them said that under oath in a federal courtroom with the defendant in the room. And in the eyes of the law, neither of them was defrauded. Hold that sentence. We are coming back to it. And then the case became a fraud case about money. To convict someone of defrauding a patient, a prosecutor has to prove that the defendant intended to deceive that patient, not the market, not the board, that person. Watch what the chain does to that sentence. 1. Nobody in the chain owned the result. Theranos ran the sample. Walgreens hosted the counter. A physician read the number and made a decision. The patient was handed a piece of paper. 4 parties touched a single blood test, and not one of them was the author of the whole thing. 2. The paperwork was signed by someone who was not the defendant. This is where the gatekeeper sits, and every case on this channel has one. A clinical laboratory does not run on executive enthusiasm. It runs on a licensed director who certifies that the work meets standard. That signature is the entire point of the license. It is the state's answer to the question of who is answerable for a number sent to a sick person. In sworn testimony, the lab director, who came in near the end, described voiding results that had already gone out to physicians. He was never charged with anything. I am pointing at the signature line, not at him. The signature line is where the chain was supposed to stop, and it did not stop. Those certifications are real. They are dated, and they sit between the executive suite and the patient. Every one of them is a place where the question could have been asked by someone whose license depended on asking it. 3. Intent gets thinner every time it passes through a hand. A jury can look at a specific investor, a specific meeting, a specific set of financial statements, and find intent in the room. Ask the same jury to trace intent from an executive suite, through a laboratory, through a retail counter, through a physician's judgment, to a person in a waiting room. And the line goes faint. The record supports that reading. On the investor counts, the jury found intent. On the patient counts, it did not hold that. 0 is not the jury saying nothing happened. 0 is the jury saying the chain was too long to prove who meant it. I want to be careful here, because the cheap version of this story is that the system protects the rich. The harder version is duller and worse. The system is very good at proving harm, when the victim signed a cheque, and very bad at proving harm, when the victim signed a consent form. Nobody built that asymmetry on purpose. It is what you get when responsibility is divided into enough pieces that no single piece is criminal. So the question stops being about her. Which chain are you in? You're in several. Start with the one Erin Tompkins was in. A laboratory ran her sample. A retail counter handed it over. A physician read it. She received a result about her own body, and there was no single party in that sequence accountable for whether the number was true. That is not a Theranos chain. That is the chain your blood is in this afternoon. You are not asked to verify the number. You could not if you wanted to. When your retirement money is invested, someone selects a fund, someone else selects the holdings, someone else audits the holdings, and the loss, if there is one, lands entirely on you. Every decision maker in that sequence is insulated from the consequence by at least one other decision maker. When your employer certifies compliance with something, safety, privacy, financial controls, a person signs a document attesting to work that was performed by people they will never meet. None of that is fraud. That is the point. It is the ordinary architecture of a modern institution, and it is the same architecture that made a jury unable to find intent. Here is the uncomfortable part. This structure does not just make harm hard to punish. It makes harm hard to notice from the inside. 800 people worked at that company. The overwhelming majority of them did their own job correctly. A chain does not require a villain at every link. It only requires that nobody can see the whole of it. Before the last part of this, do one thing. Find the most recent result, statement or certificate somebody sent you about your own body or your own money, and look for the name of the person who signed it. Most people have never checked. In 60 seconds, you will know whether there is a name at all. The mechanism has a name. Diffusion of responsibility. The classic experimental demonstration is John Darley and Bib Latane, 1968. One caution, because this channel does not cite things it has not read the criticism of. The famous story that launched this research, the murder of Kitty Genovese, was substantially wrong as originally reported. The newspaper count does not hold up. The laboratory finding does. More hands on a problem means less felt obligation per hand, and that has replicated. So, 3 questions. They work on a company, a hospital, a fund, or your own employer. Who signs? Not who is responsible in the abstract. Whose name is physically on the document. If no name is on it, the chain has already done its work. Who bears the loss? Follow the money down to the person who actually absorbs the damage. Then ask whether that person had any voice in the decision. Does the decider ever meet the affected? When the answer is no, and there is no name on the paperwork, you are looking at a structure where serious harm can occur without anyone in it doing anything a court will call a crime. That is not a red flag about dishonest people. It is a red flag about a shape. Go back to San Jose. 4 guilty verdicts and 0 on the patients. It reads like a scandal, and for a lot of people it was. But the jury was not asked whether patients were harmed. It was asked whether one person intended to harm them through a chain of 4 other parties, and it said the government had not proved it. The chain did that. Not the lawyers. Theranos is gone. The laboratory in Newark closed. The shape did not close. Diffusion of responsibility is not a Silicon Valley story or a healthcare story. It is what happens to accountability inside any organization big enough to need a second floor. It is running right now in a building where the paperwork is perfectly in order. Somebody is going to read that paperwork 4 years from now and call it obvious. Subscribe and let's go find it first.